The following behavior took place in the courts of the Neon Department of Justice, where a licensed and duly barred attorney initiated suit against the Emergency Medical Service of the state. The suit began with the intent to initiate suit and evidence provided. Acknowledgement of suit and request for acknowledgement. Additional exhibit. Legal requirements were asked, and the administration of law was reinforced. Again, as requested, the party in charge of said department was added to the suit. Further instructions of law were provided, and as the presiding officer of the matter, your attention, please. I announce my authority as the presiding judge. Litigants be informed through these means that this court has formally received suit of complaint detailing allegations against EMS for and through the acts of an on-duty personnel. Said suit claims injuries sustained, along with other claims for which plaintiff seeks restitution and remuneration. Having requested this court, and upon determination of jurisdiction, you are hereby notified you have been sued. You are to seek legal counsel to secure your rights and be informed of your obligations under the law. Please do inform me why a police commissioner feels the need to intervene in legal affairs of the Department of Justice. Under what jurisdiction, under what authority do you make an appearance in a court or court proceeding that does not concern you? The comments that are made are intrusive and undermine administration of law. For this behavior, further attention is required. Proceeding next. Whereas the court has reviewed complaints in initial submission and is now entering the discovery phase. Defendant, you are hereby summoned to answer for allegations of suit against you, and a time frame is provided. Further, I address someone that has made contribution unnecessarily so, by stating that this affair is a civil suit, no DA required. The record has been struck or stricken for the prior submission of commentary. Further, additional commentary and interruption of proceedings by said individual suing a government official request government representation, wanting to sue EMS. A EMT was, he stated, EMS, not an individual person. You do not possess a law license, and you are hereby found directly in against the law, as you're implying and you're providing interpretation of law for which you possess no license. This is quite literally the practice of law without a license. No one has asked, you have no permission to provide commentary, you have overstepped your bounds, and you have intruded in a proceeding where you have zero jurisdiction upon. Further, entertaining said comments but not providing any access to practice law, your claim requires evident written proof of the claim you arise. The court awaits. Proof does not create an implication or authorization to practice law. The plaintiff responds. Now he is directly addressing the plaintiff. Under what authority, under what permission, and under what circumstance, if any, do you exert the authority to intercede? Someone must explain this to me. Back and forth. As the presiding judiciary officer, I ordered the plaintiff to not engage. Further, the commissioner further engages in the illegal practice of law by informing the court the very body designed by law to administer law is not receiving instruction from someone that possesses zero qualifications in law. By making such statement, you are required by law to not only offer, but actively seek proper representation of the government employees, as you are a government employee yourself. Your Honor, I believe Jello Mazur is required to not only drop this bogus lawsuit, as seen in the footage for failure to yield to an emergency vehicle, as state drivers must yield to emergency vehicles with flashing lights and sirens by pulling over to the right and stopping. The move over law also requires, I think we need to seek clarification that this move over law exists nowhere in the state of Neon. But nonetheless, said law, according to the claim, also requires drivers to move over to a lane farthest from a stopped emergency vehicle if there is more than one lane and it is safe to do so, or slow down if they cannot move over. Let's examine. Not only should I remind you that you have no authority in the courts, but let's examine your claim against the evidence provided. Shall we, Commissioner? I think we shall. Green light. I clearly see that the driver is cautiously looking through his rear view mirror to see if there is an emergency vehicle in sight. There is none. Right? The evidence provided shows no immediate vehicle within the vicinity of the driver. Up until last minute, bear in mind that a emergency vehicle with sirens on does not authorize any driver from their obligations to the traffic code. Understand, there is a red light. The driver must obey state signs and engineering controls. His vehicle has come to a complete halt. Nonetheless, it is the responsibility of the driver in the red vehicle to ensure safety, not only to whomever he is going to provide medical treatment to, but also to those around him. If a vehicle is stopped because they have to abide by the law, your siren does not imply nor authorize any other driver to do what? To break the civil code or the transportation code. There was another 2 lanes on the opposite end that could have been utilized, and you could legally utilize as you have your sirens and lights on. Nonetheless, that is reckless driving, whether your sirens are on or not, as you are not ensuring safety. Nonetheless, moving forward. All right. Moving forward. I'll read it again. The move over law also requires driver to move over to lane farthest from a stopped emergency vehicle. That vehicle, or that emergency vehicle, was not stopped. It was ongoingly moving. But the justification is here. If there is more than one lane, and it is safe to do so. Commissioner, you truly are you truly are frustrating the means of justice at this point. Or slow down if they can't move over. The plaintiff was at a complete halt and stop, Commissioner. But the issue is not the claims you're making. The issue lies with you practicing law when you're not authorized to do so. Commissioner Durian Senomi, you do not possess a law license. Be advised, the practice of law within the courts is prohibited without a law license. You are stepping into the affairs of the court without the affair being associated with you or in any way creating inclusion of your contributions. For this blatant disregard to law, the court will seek punishment. Doesn't matter what your title or position is. You will not interfere. You will not influence through any means the decision-making autonomy of a judicial officer. This you are very well aware of. This is not the first time that you do this. And that is primarily the only reason why it